This is a production of SDPB.
South Dakota Town Hall Forum. Tonight we'll hear from candidates for the Public Utilities Commission and hear pro and con positions for the ballot initiatives, amendments, and referendums before South Dakota voters this year. Vote South Dakota is a partnership between South Dakota Broadcasters Association, South Dakota News Media Association, South Dakota Newswatch, and South Dakota Public Broadcasting. I'm Jackie Hendry, host of SDPB's South Dakota Focus. We're broadcasting live from the Sherman Center at Dakota Wesleyan University in Mitchell. We've worked in partnership with the McGovern Center at DWU and the university to bring you this forum tonight. I'd like to introduce Dr. Daniel Kittle, the president of Dakota Wesleyan University, for a brief welcome.
Good evening, everyone. On behalf of my colleagues at Dakota Wesleyan University and our alumni around the state and around the world, it is my pleasure to welcome you to tonight's Vote South Dakota Forum. We are honored to partner with South Dakota Public Broadcasting, South Dakota Newswatch, and the DWU McGovern Center to host this important event. It is truly an honor for us to host this forum because we care deeply about the future of our communities in South Dakota. At Dakota Wesleyan, we are guided by our core values of learning, leadership, faith, and service. And we aspire to create a community where individuals are challenged and encouraged to lead lives of meaning and purpose. Tonight's event aligns perfectly with that vision by promoting informed civic engagement and thoughtful dialogue. I am deeply hopeful about the future of our state because every day I have the privilege of working with extraordinary young people who are passionate about making a difference. And events like this also fill me with optimism as they bring together individuals who are committed to being informed and engaged in our civic life. We are particularly proud this evening of our students here tonight who have had the opportunity to collaborate with journalists from across the state to help shape tonight's discussion by asking thoughtful and insightful questions. So once again, welcome to Dakota Wesleyan University. We encourage you to return often, whether for events like this or to engage with our community in other ways. We are always eager to foster dialogue and collaboration that benefits not only our students, but the state of South Dakota. Thank you and welcome.
We'll begin tonight with learning more about the candidates running for the Public Utilities Commission. The PUC regulates electric, natural gas, and telephone utilities, issues permits for energy projects, pipelines, and other projects, and handles other duties. There are 3 Public Utilities Commissioners. Members are elected to 6-year terms, and elections are staggered. Candidates on the ballot this year are Libertarian candidate A. Gideon Oaks. He's a small business owner in Keystone who has been elected twice to the town board. He's also served on the boards of the Black Hills and Badlands Association and United Way of the Southern Black Hills. Mr. Oaks was not able to be with us tonight. Democratic candidate Forrest Wilson. He's the club director for the Boys and Girls Club of Lead Deadwood and was nominated for PUC by the South Dakota Democratic Party. He attended Northwest College in Wyoming. He's worked at several universities around the Midwest, including South Dakota Mines, before being part of the Boys and Girls Club. Mr. Wilson was also not able to attend tonight. Republican incumbent Christy Fegan currently serves as the chairperson of the Public Utilities Commission. She was appointed to the PUC by then-Governor Dennis Daugaard in 2011 and was re-elected in 2012 and 2018. She also served in the South Dakota House of Representatives from 1994 to 2001. Commissioner Fegan, thank you for being with us tonight.
Thank you.
Joining me in asking the questions is DWU student Alex Rivera. But before we begin, because PUC commissioners are in the unique position of having both an administrative role and a judicial role, candidates for this office must be cautious in weighing in on matters that are pending or imminently pending before PUC. So we are limited by state statute to talking only about process and making decisions tonight. Alex has your first question.
You served on the Public Utilities Commission for 13 years. Why are you seeking re-election?
Alex, thank you for the question, and thank you for being involved. As a Public Utilities Commissioner, you really need to understand the technical expertise of electric, natural gas, pipeline safety, siting dockets, grain elevators and grain buyers. And so there's a lot of expertise, and it takes a long time, Alex, actually, to learn my job because of the technical expertise we know. So now I'm at a point where I've studied the Public Utilities Commission and the law a lot, and I can bring that value to our ratepayers and everybody involved that comes in front of the PUC. But more importantly, Alex, now South Dakota has a voice nationally. So tomorrow, I will be chairing the Resource Adequacy Leadership Team in 14 states that makes decisions on policy on keeping the lights on right here at DWU because of Northwestern Energy. And so I'm the chairman of that, and there will be about 200 people involved in that meeting tomorrow. And that makes a difference for South Dakota ratepayers.
Commissioner Fegan, your second question. Your opponents express concerns about the influence of special interests in the PUC's decision-making process. What sources of information do you prioritize in your decision-making?
Special interest in the process? Okay. So the Public Utilities Commission is different. When I was a legislator back in the 90s, I could make my decision any way I wanted. But now as a Public Utilities Commissioner, I can only make my decisions based on the record and the facts and the evidence in the evidentiary hearing, different than being a legislator. Now I'm quasi-judicial, and that's different. So you look at our track record. Our decisions can be appealed to the Circuit Court, the Supreme Court, and they are. Our decisions are appealed. But in over 21 years, our decisions have been upheld in the Supreme Court. So, since I've been here for 13 years, our decisions have always been upheld because we make our decisions based on evidence and facts. Alex, it's your turn.
How much of a role does public opinion and public input play in your decision-making?
Public role and public input. Great question. So at the Public Utilities Commission, we work for the public. And so we give access to the public, but in a different way, very much different than being a legislator. So for like a siting docket, so there was a wind development docket right in front of us now. We drove to Clear Lake. Actually, my husband, Tim, drove me to Clear Lake because he's my driver now because he's retired after 40 years of teaching. But he drove me to Clear Lake, and we had a public input meeting of the people impacted in that area, and the whole public was invited. So that was a public input meeting. Then the public can send us comments. They can become a party in the docket and have a legal standing if they adhere to the law of the party status. Anybody can send us comments, but it can't be to me personally. It has to be to the Public Utilities Commission so everybody can read the comments and that we're transparent. So what you'll find out, Alex, about the Public Utilities Commission is we're transparent, we're accessible to the public, and we make our decisions based on facts and evidence.
We have time for one more question, Commissioner
Only
Fegan.
one more?
Only one more.
I'm only getting warmed up.
What are you most proud of from your tenure with the Public Utilities Commission thus far?
So what I'm most proud of the lights went out in February of 21 because of Texas. And I was the chairman of the Resource Adequacy Group, the commissioners in the 14-state footprint that are responsible for resource adequacy. The only regional organization in the country that the commissioners are in charge. So I have taken a leadership role, have spent thousands of hours studying resource adequacy to protect South Dakota ratepayers and try to keep the lights on.
That's our time for this topic. Commissioner Fegan, thank you for joining us tonight. Alex, thank you as well.
Thank you, DWU. Love it. This is where my mom actually got her teaching degree, so great to be back here.
There you go. As we move into the debates on issues, we have asked the participants to keep their answers short and to have a closing statement prepared. Before this live broadcast, we drew for which side will have the last word. Up first, Constitutional Amendment H establishes top 2 primary elections. Currently, only members of the candidate's party may vote for that candidate unless that party has opened the primary to voters not affiliated with the party. Candidates for the following offices are impacted by this amendment: governor, state legislature, U.S. Senate, U.S. House of Representatives, and elected county offices. Minor party candidates may be chosen by primary or party convention. This amendment allows all voters may vote for any candidate. The 2 candidates receiving the most votes advance to the general election. If there's more than 1 candidate to be elected to an office, the number of candidates advancing to the general election is twice the number to be elected. A yes vote adopts the amendment. A no vote leaves the Constitution as it is. Speaking as an advocate to Amendment H is Tom Dempster with South Dakota Open Primaries. Speaking as an opponent to Amendment H is Julianne Talkington. She's the East Side Coordinator for No on H. Stu Whitney with South Dakota Newswatch and DWU student Trina Lapp will ask the questions.
Republican and Democratic state party leaders have both come against this amendment, saying that open primaries will reduce the power of political parties in the state. Is this a legitimate concern on their part?
Thank you for the question. I'm not sure that I totally agree with the point that you're making. I think that the problem in general with the amendment is it makes it so that people that don't have a lot of money have trouble running for office.
May I take a crack at that? Sure. It requires a little bit of perspective in order to answer that question. The first thing that you need to understand about open primaries is that it's easy peasy. When open primaries passes, the ballot we have in the primary will be exactly the same ballot that we have on the general election. In the primary, all of the candidates will be on one ballot. Everyone will get to vote for those candidates. Everyone gets to vote for the candidate of their choice, and the top 2, the winners of that primary, go to the general election. It's easy peasy. All candidates get to vote. All voters get to vote for who they want to. All candidates are on one ballot. The top 2 go to the general election that then stand before the voters. It's easy peasy. It's easy to understand. The second thing that you really need to understand is Article 7 of the South Dakota Constitution says this: elections shall be free and equal. Elections shall be free and equal. It also says every citizen 18 years and older shall be invited or shall be entitled to vote in all elections. If you believe our Constitution means what it says, if you believe in the dignity of mankind, if you believe we are all created equal, you will be dismayed to hear that 15,300. You will be dismayed
10
to
seconds.
hear that 15,300 people cannot vote in the most important election in the state of South Dakota.
We do have limited time, so I'm going to get to our next question. I'm going to ask you, are open primaries a genuine strategy to improve South Dakota elections, or merely a reaction to changing tides in the Republican Party, specifically moderate Republicans being challenged or beaten by populist candidates in recent primaries?
Stu Whitney, that's a fabulous question.
Appreciate that.
You're welcome. Right now, in our most recent primary, 21 out of 35 of the Senate and over 50% of the House are already elected by the primary election, in the primary election. Who elected 21 of 35 members of the Senate? Who elected over 50% of the House? I'll ask you this. Was it 100% of the voters? 90% of the voters? 80% of the voters? 70% of the voters? 60, 50, 40, 30, 20? No. 15% of the voters in the primary elected 21 out of 35 and over in the Senate, and over 50% of the members in the House.
I want to give Julianne a chance to weigh in on that.
So I'd just like to talk about what's happening in two of the states that have, there are two states that have top two primaries, California and Washington. And one of the big arguments that we're hearing is that everyone cannot vote in South Dakota. I'd like to cover some of the data from that a little bit later. It pretty much shows that there's really no improvement in voter turnout for primaries. And another thing is that right now, everybody can vote in the primary. I've worked the past two primaries as both a superintendent and a worker in the polls. We had independents, we had Democrats, we had Republicans all voting. And if somebody wishes to change their party affiliation and they're Republican and wishes to vote as a Democrat, that can be done with about 3 minutes of time. If you're a Democrat, you want to vote as a Republican, you can do the same. If you're an independent and you want to vote as a Republican, all those options are available to you now. And every time I've worked, I've had independents voting. So everybody is already voting in the primaries now.
May I respond to that?
Briefly, Tom.
I will. Furthermore, because 15,300 people cannot vote in the most important election in South Dakota, they help to pay for that primary election. You are asking them, in order to vote in the Republican primary, to become something that they're not. 15,000 people cannot vote in the election that elected 21 out of 35 of the Senate and over half of the House. Washington, California, top two primary states. South Dakota had a 17% turnout in their primary. Washington and California lead the country for primary turnout as a result of satisfaction with primaries.
Do we have time for another one?
Yes.
Trina?
If Amendment H passes, what necessary procedures would the legislature have to take to implement the changes to state elections?
I think the question is, if Amendment H passes, what has to happen in order to implement all of the changes? The legislature exercises their plenary power in order to make new legislative rules that will implement open primaries, that will implement H, that will be consistent with the South Dakota Constitution.
Well, I'd like to comment that right now, it requires that everyone be able to vote. And if we change this, there are parties that would never have a candidate on the ballot. Because if we go to a top two primary, that would mean right now most of the people in the state are Republicans, and likely those top two candidates would be Republicans. And so you could have independents and Democrats that could possibly never be on the ballot.
Tom, what about that point? A lot of Democrats have mentioned that it's already a one-party state, essentially, and they're worried about getting shut out of top two primaries and making South Dakota even more of a one-party state.
Sure,
because you have different types of Republicans, perhaps.
Yeah, Stu, thank you. I believe it's Democrats' responsibility to elect Democrats. It's Republicans' responsibility to elect Republicans, for sure. Democrats have had the capacity to sit on their hands, if you will, because they're guaranteed a spot in the general election. Republicans have had the opportunity to sit on their hands, if you will, because they're guaranteed a spot in the general election. Some years ago, I ran for the legislature in District 15 as a Republican, at the time the heaviest district, the heaviest Democratic district in the state. David Kranz, good friend of many of us, said there's going to be a Republican upset in District 15. When the votes came in, I thought I was going to win, a Republican in a Democratic district. When the votes came in, I wasn't first, I wasn't second, I wasn't third. I was dead flat last. And that's my lesson in politics, that in order to win in politics, in order to win the primary, whether you be a Libertarian, Democrat, or Republican, guess what? You have to work hard and you have to get votes.
Julianne, the Attorney General's statement for Amendment H notes that a candidate can list any party next to their name on the ballot, regardless of their actual party affiliation or registration. Should this be a concern for voters if the amendment passes?
Yes, that should be a concern, basically because things should be transparent, and people should have the ability to know what the person stands for and what party they're affiliated with. And so, yes, we should be about transparency. Another thing that is of great concern to me, and I just want to cover this now because I think it is related. My colleague here stated that there was a radical difference in turnout in primary elections. I have the data here in front of me, and I'd be happy to share it with any of you, but it has not changed voter turnout in California at all for the primary elections. Those are actually very similar. In fact, they've had almost duplicate numbers to what we've had in South Dakota. So if we're going to be changing our Constitution, we should be changing our Constitution for a valid reason. We should be making it more transparent. We should be making it easier for people to actually participate, not more difficult. In California, what has happened is that you have to have a tremendous amount of money to run. And that has skewed things so that you can have somebody who's very radical, who is actually elected to office because they have someone behind them with a lot of money. Unlike the head of the Democrat Party, Mr. Allers, and Bethany Soy, who is a Republican, who literally ran their first race with a couple $1,000s and walking to every house to get elected, we'll have people that it requires hundreds of thousands of dollars even to get through the primary.
Tom, do you want to weigh in on that one?
Sure. With respect, that's ridiculous. South Dakota is an open state. Our legislative districts are relatively small, at least in urban parts. I've walked every last one of my legislative districts. I've knocked on every door. It's a matter of work. Do you have to raise money? Absolutely, you have to raise money, but your capacity to raise money is somewhat of a testament of your value as a candidate. Like I said, early in my political career, I learned that in order to win elections, you need to get votes. It takes a lot of work to get votes. Anybody can do it, but it takes a lot of work.
We have another question.
What would be the long-term impact of Amendment H on South Dakota's political landscape?
I think it would be huge. All you have to do is look at Washington and California. I lived in both states prior to the equivalent passage of Amendment H. Both states had high levels of creativity. There was a lot of ability for people to be successful if you had small businesses or large businesses. What happened in both states after the passage is a move to corporatization. Because the elections are so expensive, now you end up with very fringe candidates in office. And as a result, I honestly think in California now, it would be impossible for Steve Jobs to start Apple Computer. The cost is so much, the crime is so high, the taxes are out of control. We don't need that in South Dakota. We have a great system going on here now. Someone literally can run for office because they don't like what's going on for a couple $1,000s. We need to keep it that way so everyone can participate and everyone can be part of the system.
Open primaries in the state of Washington or in the state of California has no more impact on the economy or no more impact on their jobs than it has on the beautiful 1,000-mile coastline in California, where you've got the redwood forest on the north and you've got the palm trees on the south. Here's why open primaries are important for South Dakota. Had we had open primaries, the top two moving to the general election, had we had open primaries in the state of South Dakota today, over 90% of the South Dakota, over 90% of the South Dakota legislature would be elected by all of the people who vote in the general election, rather than the 17% of people who vote in the primary. Do you think for a second that those people who are elected in the is it not better for those people who are elected to respond to all of the people in South Dakota rather than being held to respond to just 17% of those people who voted in the primary? What we get in exchange is we follow our Constitution. We do what we say that we believe, that everybody is free and equal, and that everyone 18 years and older shall be entitled to a vote in all elections. We have a better democracy, and we certainly have a better economy as a result of it.
We need now to move on to our closing statements. We drew ahead of the broadcast for who goes first and last. Mr. Dempster, for the proponent side, you go first. 1 minute closing statement.
Sure, happily. Again, easy peasy. Open primaries are easy to understand. The top two in the primary move to the general election where all voters vote. Secondly, Article 7 of the Constitution, elections shall be free and equal. Every citizen 18 years and over shall be entitled to vote in all elections. 150,000, no, it's 153,000 people cannot vote in all of those elections. Finally, our legislature is elected by all of the citizens, rather than just rather than most of them elected by 17% of the voters. Imagine the difference.
Ms. Talkington, you have the last word. 1 minute closing statement.
Yes, I'd like to just reiterate that in the state of California, they're looking at the same percentages that we are for participation in primary elections. They also had a primary election where only 18% voted in the primary election. We have had primaries in the 30%, and they have as well. They have never had a primary election in the 40%. We have not either. So this seems like a pretty extreme measure to change our Constitution to get exactly what California has right now, and also to get all of their problems that they have in California with the crime, the corruption, and the very fringe candidates that they're now having elected. I also want to just reiterate that everyone can already vote now. I work in the polls. Independents, Democrats, and Republicans vote now. It's very easy to change and move to a different party if you wish to. And the other thing that's extremely concerning to me is the fringe candidate problem. We do not need fringe candidates like they have in California here in South Dakota. We need to be able to have people of all walks of life involved in the process, not very extreme fringe people.
That's our time for Amendment H. I want to thank our participants, our journalists, and our student for asking the questions. We'll turn now to Initiated Measure 29. This is the third consecutive election cycle that South Dakota voters are asked whether recreational marijuana should be legal in the state. This measure allows individuals 21 years of age or older to possess, grow, ingest, and distribute marijuana or marijuana paraphernalia. Individuals may possess up to 2 ounces of marijuana in a form other than marijuana concentrate or other marijuana products. Individuals may possess up to 6 marijuana plants with no more than 12 plants per household. The measure places limits on the possession of other forms of marijuana and marijuana products. Under the measure, the possession, ingestion, and distribution of marijuana and marijuana paraphernalia remains illegal for individuals under the age of 21. Driving under the influence of marijuana remains illegal. The measure restricts where individuals may possess or consume marijuana, such as schools or where tobacco is prohibited. Employers are allowed to restrict an employee's use of marijuana. Property owners may also regulate the use of marijuana on their property. The measure does not affect state laws dealing with hemp. It also does not change laws concerning the state's medical marijuana program. The measure legalizes marijuana-derived substances considered felony-controlled substances under state law. Marijuana remains illegal under federal law. A yes vote adopts the initiated measure. A no vote leaves South Dakota law as is. Speaking in favor of initiated Measure 29 is Matthew Schweik, Executive Director of South Dakotans for Better Marijuana Laws. And in opposition is Rhonda Milstead, Executive Director of Protecting South Dakota Kids. Patrick Lally of Forum Communications and Sioux Falls Live, and DWU student Seth Foote will ask the questions. You may begin.
Matthew, we'll start with you, and then Rhonda, you'll go first with the second question. Marijuana distributed today illegally is a much higher potency than past generations. We also know that marijuana is not the only way to ingest THC these days. There's gummies and creams, vaping, dabbing, which I just learned about not so long ago, can all deliver much higher levels of THC. If this passes, should there be caps on the amount of THC that is present in various products? Matthew, go ahead.
The simple answer is yes. I will point out that Measure 29 does not include provisions that call for regulated sales. That's a policy that the legislature would have to handle after the passage of Measure 29. I consider myself a conservative legalizer in the sense that I support strong rules on packaging, labeling of products, and I absolutely support THC caps on products. I don't think there's any need for ultra-high THC products. And this is the benefit of legalization and regulation. Instead of leaving it to the black market and leaving it to dealers who don't check IDs, who do nothing for product safety or product labeling, product packaging, we can shift sales behind the counters of licensed, regulated, tax-paying businesses, and we can do exactly that, control the strength of THC products, because whether we pass Measure 29 or not, cannabis already exists in South Dakota. The question is, are we going to be pragmatic and take a common sense approach, or are we going to stick with an obsolete, failed policy of prohibition that has done nothing for us for a century?
Rhonda?
I don't think any levels of THC are going to be safe for people. It's been proven over and over again by the American Medical Association, Pediatrics Institutes, and Science Direct that THC is damaging to adults as well as children. So why do we regulate levels? And you know, the other thing is, we talked about the black market. You just mentioned it. Black market in states is much higher sales than any legal market. So we're not going to be able to control the THC. So I invite trouble into our state in the form of a drug that is not safe, that is not responsible, and will never be regulated.
Before we move to our next question, just a quick reminder to our audience to please hold applause and other remarks until the end of each segment. Please go on.
I also want to point out that DWU student Jack Ducheneau is actually sitting in for Seth. So
thank you.
He will take the second question, and it'll be for Rhonda.
How will past marijuana-related convictions be handled if the measure passes?
You know, I'll give you my personal feeling. If you broke the law and you were involved with marijuana, you made a choice, and so that is the consequence for that choice. But I'd also like to point out that what the proponents are saying is that people are in prison for ingesting marijuana, and that's not true. If you call any state's attorney in the state, you're going to find out that people aren't in for ingesting. They did something else, and their was reduced down to ingesting just because the courts and the dockets are too full. The other reason people are in prison for ingesting is that they broke parole. They might have been in prison for burglary or domestic abuse, but they violated the probation because they used drugs. That's why they're there.
May I have a rebuttal? I'm just going to point to an article by South Dakota Public Broadcasting that noted that there are 241 inmates in prison for ingestion, costing roughly $30,000 a year each. That's a total of $7.2 million per year. Senator Milstead's correct that some of those convictions were pled down, but the simple fact remains that adults are being deprived of their freedom and locked in prison for a plant that is less harmful than alcohol. You know, I would understand somebody standing here saying alcohol should be illegal and cannabis should be illegal. At least there would be some consistency, some logic there. But to tell people, go drink as much alcohol as you want, even though it is far more addictive and can actually kill you and causes more violence and destructive behavior. But if somebody ingests cannabis, and fun fact, South Dakota is the only state in the entire country in which you can be prosecuted for having cannabis in your bloodstream. That is how severe our cannabis laws are in this state. If you're caught with 1 gram of cannabis in South Dakota, in theory, you could face up to 1 year in prison. These are crazy laws that are completely at odds with what people want in this state and completely at odds with any basic sense of fairness and common sense.
Comment?
Yes.
Over sensational, over dramatic. If you talk to law enforcement, they're not stopping people for having an ounce of marijuana on them. That's not happening. And to compare alcohol to marijuana, there is no comparison. Alcohol is water soluble. People take a drink and within 2 hours they flush it out of their system. Marijuana goes into the fat cells in your brain and it can last there for 5 to 7 days. Marijuana causes psychosis, it causes violent reactions. You don't know what it's going to do to you. Alcohol is different.
I must
10 seconds. We need to move to the next question.
Matthew, I have a follow-up question to that will go to this point, and I think will clarify. We're talking about alcohol. From your perspective, what is the difference between marijuana and alcohol and even nicotine when it comes to addiction and abuse?
Well, the math is pretty clear that nicotine and alcohol are more addictive and kill hundreds of thousands of people every year. I'm not here advocating to adopt prohibition on tobacco. That would be a disaster. We would create a massive black market and fuel the criminal economy. I also am not here to advocate for prohibition of alcohol because, as we saw, that was a total failure and created organized crime in our country. And I'm just extending the same logic to cannabis, which has also had a policy of prohibition that's also failed. I must respond, though, because you are very dismissive of the idea that alcohol is dangerous. Let's use a very simple measurement here. If you put enough cannabis in your body, you cannot die. If you put too much alcohol in your body, you will die of alcohol poisoning. So on this very basic measurement of which substance can end your life, alcohol is more dangerous. And the last thing I'll say is you're dismissive of, you say I'm sensationalist. I've met these people. I've met people who've had their lives ruined, disrupted, derailed by cannabis arrest. I've met people who've lost access to housing, to scholarships. There's people who can't serve in the military. It even can affect your Second Amendment rights. So it's easy, I think, for you to dismiss this, but there's a real world effect and toll of cannabis prohibition. It ruins people's lives for no good reason. It's a total overreach of government power and authority.
Rhonda.
Cannabis and addiction. Across this nation, drug treatment centers and counselors have proven over and over that marijuana leads to other drug addictions. That's what kills people. They're addicted to meth, they're addicted to opioids, they want something more. That's where marijuana leads. You talk to law enforcement in the state and they'll tell you that people who are on meth or on opioids or getting caught with fentanyl, it's because they started with marijuana. I'm not saying every marijuana user goes to those levels, but they don't use less, they use more. That's what's dangerous.
But the question is there a difference between marijuana and alcohol addiction? At its core, do you believe there's a difference between those two?
There is a difference. People drink alcohol. I mean, how many people are social drinkers? They have a drink with dinner. They're not addicted to alcohol, but there are people that become addicted that drink too much. But there's a difference. Marijuana is an addictive drug from the very first one. That's the difference.
Matthew, do you have any rebuttal?
I'm trying to find the exact numbers so I can read them to you, but it's pretty clear based on the science that nicotine and alcohol are more likely to become addicted to them. But let's talk about the gateway theory, this idea that you try cannabis and all of a sudden you want to do hard drugs. It's been refuted, it's been debunked. The real gateway is prohibition. Your policy is the gateway, because the reason I say that is right now, if you're going to go buy cannabis in South Dakota and you don't have a medical card, you're going to a dealer. And guess what? The dealers don't check IDs, they don't have any safety, and they might be selling other substances. Whereas if you're in Alaska or Montana and you go buy cannabis, you're going to a licensed regulated business. It is prohibition of cannabis that exposes people unnecessarily to harder drugs in our society. If we could shift cannabis out of the illicit market and put it into regulated businesses, we will reduce exposure to harder drugs that dealers are often offering people who just want to buy cannabis. So if you're concerned about the gateway, prohibition is the gateway, and Measure 29 legalization is reducing exposure to hard drugs in our society.
We have time for one more question before our closing statements.
What are the projected tax revenues from legalized marijuana? The LRC fiscal note says that it's minimal because the distribution of marijuana would still be illegal. Should any tax money that does come in simply flow into the state's general fund, or should it be specifically used for substance abuse and recovery programs across the board?
Rhonda, that's for you.
I think he should answer first because I don't think there's revenue.
You're correct. There is no revenue. This initiative only legalizes possession. We would have liked to have written a comprehensive initiative, but due to the ruling in the Amendment A case, which you'll recall is when a court overturned the will of 54% of South Dakota voters after the 2020 election, due to the precedent established by the Amendment A ruling, it restricted us in terms of how broad a policy we could craft in Measure 29. So this is bulletproof, it's airtight, and it's just about possession. Now, our expectation is if we pass Measure 29, the legislature will hopefully pass an implementation bill that would set a tax rate. In terms of how that revenue is allocated, I would be comfortable with it going to the general fund. I would also be comfortable with it being dedicated to substance abuse treatment. I would respect the legislature's decision on how to allocate those funds.
There is minimal revenue possible from paraphernalia and some different associated products with marijuana that's mentioned in the LRC note. Any specific use for that, Rhonda?
Well, I guess I'd like to comment on the overall revenue. I mean, they're saying that there will be $100 million in revenue, and talking whenever they go and they fight for recreational marijuana to be legalized in the state, they're saying there's going to be this great revenue stream for the state. Well, I mean, in Colorado, it's $1 in, $4.50 out. The states that have legalized it aren't finding this revenue. If they would, they'd be paving their streets with gold. And what are they? Lining up tents on their streets. That's what happens with marijuana. There's not revenue. And to say $100 million in revenue is going to come into our state, we're saying that if we pass IM 28, we're going to lose $100 million in food tax, and then we're going to replace that with $100 million in marijuana. That's a lot of marijuana sales, and I don't think that's reality.
I just want to clarify one thing, Matthew, and it should be, I think, a quick answer. Under this, there is no provision to allow distribution. There won't be dispensaries on the corner unless the legislature takes further action, correct?
Correct.
30 seconds for these responses, please.
Correct. I also just want to rebut the study you cited, the $4.50 spent for every tax dollar brought in, totally has been disproven. It's from the Centennial Institute, the Colorado Christian University. They had really wacky ways of coming up with their numbers. The proof is in the pudding. $15 billion of tax revenue have been generated by states. That includes $132 million in just a couple years over in Montana. The revenue is real, and the idea that it's being... Got it.
Revenue's not real. I mean, what they're spending in extra law enforcement and medical costs, an emergency room, mental health illness, there's revenue, but there's 4 times the cost that by legalizing marijuana.
Mr. Schweik, you have 1 minute for your closing statement, please.
Well, I want to start with a very simple message. This is about freedom, and it's about what power you think the government should have over your life. do you think the government should be able to lock you up for possession of a plant that is less harmful than alcohol? Does that seem like it's respecting individual liberty or personal responsibility? I do not think so. I think that when you give the government power to lock you up, to take away your freedom, you better have a very good reason for giving the government that power. And cannabis prohibition is not a good enough reason. I want to finish with this. I'm sure my opponent will finish with a number of claims about how terrible legalization is across the country. I hear it endlessly from the opposition campaign. They're pretty loose with the facts, but I'll finish with this. 24 other states have legalized cannabis for adults 21 and over. In those 24 states, and that's happened since 2012, not a single one of those states has repealed the policy. In none of those states has a repeal bill passed even a state house or a state senate, let alone a state legislature. In none of those 24 states has there been a ballot initiative to repeal legalization. If even 10% of what my opponent says is true, wouldn't we have seen one state take one step towards repealing this policy? Instead, we've seen no desire to repeal it because the policy works, because it's common sense, and it respects personal freedom. Thank you.
Rhonda Milstead, 1 minute closing.
Why should you vote no on Initiative Measure 29? When choosing on any ballot issue how to vote, the questions that you should ask and be answered are, what are the benefits and the risks for me personally and for South Dakota as a whole if this proposal passes? Legalizing marijuana has serious potential harm, risk for individuals, for communities, and the state of South Dakota with no identifiable benefits. As proven by state after state after state, this drug brings more poverty, more crime, more mental health issues, more youth at risk, more violence, more addiction. It's selfish, it's unsafe, and it's unhealthy for users and non-users. You need to do the research for yourself and think about kids. At the very base, is it worth harming our children and destroying their future by a drug that will make them ill, if not kill them? So think about it before you vote. Thank you.
That's our time for Initiated Measure 29. Thank you to our participants and to our journalist and student for the questions. Constitutional Amendment F is an amendment to the state constitution authorizing the state to impose a work requirement on individuals eligible for expanded Medicaid benefits. In 2022, voters approved a constitutional provision that expanded Medicaid eligibility for any person over age 18 and under 65 whose income is at or below 133% of the federal poverty level, plus 5% of the federal poverty level for the applicable family size. Constitutional Amendment F does not identify any specific work requirement that may be imposed on those receiving expanded Medicaid benefits. Any work requirement proposed by the state must be approved by the federal government prior to implementation. South Dakota legislators passed Senate Joint Resolution 501 during the 2024 legislative session to add a work requirement for adults who are not physically or mentally disabled to the state constitution. A yes vote adopts the amendment. A no vote leaves the Constitution as is. State Representative Tony Venhuizen represents District 13 in Sioux Falls. He was the prime sponsor of this measure in the House and is speaking in favor of Amendment F. Opposing Amendment F is Shelley TenNapel. She's the CEO of the Community Healthcare Association of the Dakotas. Mel Olson from KMIT Radio and DWU student Cannon Beaver will ask the questions. You may begin.
Amendment F does not establish a baseline for the number of hours a recipient is required to work. What would you propose would be an estimate of the amount of time a Medicaid recipient would be expected to work in order to receive benefits, and what would be considered as work?
Well, thank you for that question, and thank you for having us here tonight. You know, I think it's important to understand what Amendment F does and what it doesn't do. This amendment is not about establishing a work requirement. It's about removing a prohibition that's in our Constitution. The amendment that passed to enact Medicaid expansion has language in it that precludes a work requirement from even being considered. What Amendment F would do is remove that prohibition so that a future governor, a future legislature could consider enacting a work requirement. That also requires approval from the federal government, and presumably would mean that we would need to have a different administration in the White House that's willing to entertain a work requirement. To your particular question, though, South Dakota has work requirements in our other social programs, the SNAP program, which is commonly called food stamps, temporary assistance for needy families. In those programs, there's a baseline of hours that has to be worked, not full-time, but part-time or better. And there are also some reasonable exceptions. If you're a student going to school, you're not expected to work. If you're a parent staying home with young children, if you're caring for a sick relative, if you're ill yourself, if your health doesn't allow you to work, or if you live in a part of the state where you can't find a job, like in our reservation communities. These are exceptions that are already in place in South Dakota in our other social programs. I think it would be highly likely, I'm very sure, that the legislature would have the same exceptions, and frankly that the federal government would require them as condition of approving a waiver to enact a work requirement.
Thanks for your question. I think it goes exactly to the problem with Amendment F, which is that, first of all, this is something that the South Dakota voters voted for just a few months ago in the 2022 election to expand access to health coverage. And now we're being asked to vote on an amendment that would restrict that coverage, where we have we have no information available about how those restrictions would be put in place. So to his point, I think there's a sense that there are people who get a cancer diagnosis and find that they can't work. Should they lose their life-saving health coverage in order to, because of this work requirement? And I think the answer to that is we don't know. What about stay-at-home moms? Are they going to be forced into the workplace in the middle of a child care affordability crisis? The answer, again, is we don't know. So I think, there's a whole range of scenarios that are just unclear and undecided in this amendment. And I think, we're being asked to just trust that government bureaucrats are going to know what's right for the South Dakota people in terms of whether they deserve health coverage or health care. And I just think that that's not the right way to go.
Good evening. Representative Van Heusen, your opening remarks about how we're not establishing work requirements, we're just removing a prohibition, reminds me of the story of the Quaker who heard a disturbance in his garage, and he said, "Friend, I would not hurt thee for the world, but thou standest where I'm about to shoot." Clearly, we're removing a prohibition so we can add a work requirement. There are only 2 states in the United States that have one, Georgia and Arkansas. Arkansas requires people under the age of 50 to work 80 hours or do community service. It has cost that state $26 million to administer. They've added nobody to the employment rolls in a significant way. Why would South Dakota take on administrative cost, additional state employees, enforcement mechanisms, bureaucrats, business regulation in a state that has 2% unemployment? Who's freeloading?
Thank you for the question, Senator Olson. I don't entirely agree with the premise of your question, really in 2 ways. First of all, I don't think it's fair to assume that the purpose of this amendment is to allow us to immediately enact a work requirement. The purpose of this amendment is to keep the Constitution to its intended purpose, which is the structure of government and the rights of the people, so that policy decisions can be made through a legislative process or through initiated measure. I think there'd be a lot of questions to be considered by policymakers about how and when to enact this if it became a proposal before them. Secondly, I want to correct you. Arkansas no longer has a work requirement in place because the Biden administration pulled the plug on all of the proposed work requirements when President Biden took office. The only current work requirement is in Georgia. That is a state that has not expanded Medicaid. It's in their traditional population, and so not really comparable. The Arkansas example barely got off the ground before the COVID pandemic caused it to be shut down. During COVID, all the rules for Medicaid were basically thrown out the window for a year or 2. So I would say there really hasn't been a state that has had the time to get a Medicaid work requirement off the ground in an expansion program and have time to make it work. What I do know is that in South Dakota, we administer work requirements successfully in all of our other social programs. So I'm very confident we'd be able to do it in an efficient way.
Part of me is like, just read the question again, because you stated a lot of the facts that I think are really relevant to this case. This has been implemented in one state. It was an abject failure. It was stopped by a judge who said that people who were eligible for coverage were losing it because the paperwork, the red tape was keeping people from benefits that they were eligible for. So just to restate a few of those facts, a quarter of the people who were eligible for coverage lost it in just 9 months. So 18,000 people now who are incurring medical debt. 50% of those interviewed had medical debt, didn't seek needed medical care because of the barriers that they were facing. And many of them just reported confusion about what the rules were. This is a very complicated program. I think we know that in South Dakota because we expanded Medicaid a year ago. We know that there are 60,000 people eligible, and not even half of those are yet on the rolls because there's a need to communicate, to explain to people how to sign up, all of those things. We need to head in the right direction versus rolling this back in terms of something that in implementing a policy that has been proven to keep people from health care that they need.
Quickly before...
If I could just briefly...
Oh, I'm sorry.
Yeah. The Arkansas federal judge did not strike it down on the merits. It was a process argument. In fact, his opinion specifically said that he was not ruling on the merits of a work requirement. South Dakota was the first state to have work requirements in our social programs. It's something Governor Janklow implemented in the early 80s. What we want to do is expand that into this other program. You mentioned only half the people have applied. People apply for Medicaid expansion when they get sick in many cases. So you're going to see that go up over time. It's going up. It will still go up. It'll get to about 60,000 within a year or two.
Next question.
Just quickly before we ask the next question, people viewing at home might think that you misspoke when you addressed me as senator. I was a senator 30 years ago, and that I appreciate the honorific, but it's long past due. Go ahead, Ken.
Once a senator, always a senator.
Well, thank you. Yeah.
Amendment F only refers to those with physical or mental disabilities. What provisions would be put into place for those who already work but are not covered by employer health insurance, or for those who cannot work due to a physical or mental issue but who do not qualify for full disability? For example, people going into labor or people going through chemo.
Again, we do not know, and I think we're being asked to, again, trust the government to set up the rules and really to stand between people and their health care. I think one of the things that I would just note is, again, referring to our neighboring state in Montana, they recently did a study in terms of their Medicaid expansion population, and they found that 97% of Medicaid expansion beneficiaries were either already working, that was the vast majority of them, because we all know we need to work to pay the bills, to pay rent, et cetera, or we're caregivers, or we're disabled, or we're students. And so we're talking about 3% of the population for whom we're setting up a huge government bureaucratic program that we know will keep people who are eligible and working and disabled and all the things you just mentioned from the coverage that they need.
Representative, do you have a response to that?
Yes, I do. You know, the will of a people is important. And what's important to me about this is something that was passed 2 years ago, but the question was expansion, yes or no, right? A ballot measure is a black and white yes or no thing. If you thought we should have Medicaid expansion but with a work requirement, you couldn't write that in. There wasn't a middle box. What we're doing is we're going back to the voters and offering them a clarifying question. All right, we passed Medicaid expansion. What about a work requirement? Is that a good idea? Is that a bad idea? You know, I think it's kind of funny. This is the third time I've debated this in the last 36 hours. It's interesting to me that the advocates of government-run health care are so concerned about bureaucracy. They keep raising this question. There's no more, I mean, nothing more will expand bureaucracy than it continuing to expand government-run healthcare to more people. And when you listen, there's a very basic philosophical difference here. Are social programs a way of life? Is this a long-term plan for healthcare? Or are they a hand up for people who have tough times and a path to a better future? I think it's the latter. I think we have social programs to give people a hand up, help them get back on their feet, help them become self-supporting again. People on Medicaid expansion are, by definition, able-bodied, working-age adults. That's who they are. Now, there are people who can qualify for exceptions. Again, little kids at home, caring for a relative, cancer patient, going to school. Every social program in South Dakota has exemptions for those people. This would too. This is no more vague or open-ended than the amendment that passed expansion 2 years ago, or frankly, any of the other amendments you're going to hear about tonight. We've already heard that if open primary passes, you're going to have the legislature change the code. If marijuana passes, the legislature is going to have to change the code. You're going to hear it on a couple more, too. That's how this works. The people state their goal, one way or the other, the will of the voters, and then it's up to the policymakers to step in and fill out the details. This is no different than any other measure we're voting on this year.
We must move on now to our closing statements, 1 minute each. Representative Venhuizen, you go first. 1 minute closing statement.
Well, thank you, and thank you again for having me here. I would just reiterate something that I said a minute ago. In South Dakota, our social programs are not a way of life. They're not a long-term answer. We believe in the value of work. We don't believe a job is a punishment. We think it's good for people to support themselves, and we give them a hand up so that they can do that. That's what we're trying to do with Amendment F. I just want to close with a quote, something President Theodore Roosevelt said in his Man of the Arena speech in 1910. If a man stumbles, it is a good thing to help him to his feet. Every one of us needs a helping hand now and then. But if a man lies down, it is a waste of time to try to carry him, and it is a very bad thing for everyone if we make men feel that the same reward will come to those who shirk their work and those who do it. I think that's exactly right, and I'd ask you to support Amendment F. Thank you.
Shelley Ten-Napel, 1 minute.
I would say that Amendment F is unneeded, it's unclear, and it undermines the will of South Dakota voters who just voted to expand access to health care in our state. South Dakotans are hardworking people. As we know, our governor just stated how low our unemployment rate is. We're pro-work, and that includes me, but this is an amendment that we know already from experience does not increase employment, but it does add red tape and government bureaucracy. So I think if you want to promote work, I think one of the best ways to do it is to help people get the health care that they need. I think if you can stay healthy, take your medications, do all the things, seek preventive care, you are able to work more effectively, take care of the people in your family and your communities. So I think from a values perspective too, I would just say, one of the things that I bring to this personally is really just this idea that when you're sick, you should be able to go to the doctor, full stop, whether you have a high income or a low income. And I think that's what Medicaid expansion enables. And I think even if you don't share that value and are just pro-work, I do believe that this is a pro-work amendment.
That's our time for Amendment F. Thank you to our participants, to our journalist and student for the questions. Constitutional Amendment G establishes a right to abortion in the state constitution. This initiated amendment establishes a constitutional right to an abortion and provides a legal framework for the regulation of abortion. This framework overrides existing laws and regulations concerning abortion. The amendment establishes that during the first trimester, a pregnant person's decision to obtain an abortion may not be regulated, nor may regulation be imposed on the carrying out of an abortion. In the second trimester, the amendment allows the regulation of a pregnant woman's abortion decision and the regulation of carrying out an abortion. Any regulation of a decision or of an abortion during the second trimester must be reasonably related to the physical health of the pregnant woman. In the third trimester, the amendment allows the regulation or prohibition of abortion except in those cases where the abortion is necessary to preserve the life or health of the pregnant woman. The decision at this point is determined by the physician's medical judgment. A vote yes will adopt this into the state constitution. A no vote will leave the constitution as is. Speaking in favor of Amendment G is Nancy Turbach, chair of the Coalition for Freedom Amendment G. Speaking in opposition is Caroline Woods, the spokesperson for the Life Defense Fund. Alicia Garcia from KOTA TV and DWU student Megan Hutchison will ask the questions. You may begin.
Thank you. I'll ask the first two questions, and then Megan will ask the next two questions. The first question goes to Nancy Turbach. Amendment G does not take into consideration the viability of the fetus or whether or not life begins during the 9 months of gestation. What do you tell the South Dakotans who believe that life begins before birth?
Thank you for the question. For decades, this issue has been discussed in terms of when life begins. In some sense, that's an artificial question because obviously the egg and the sperm are alive even before they join. But certainly there are people who feel that once an egg is fertilized, that fertilized egg deserves the same protections as every one of us that's walking, living, and breathing. And to those people, I would say, I respect your opinion and I respect your values, and no one should ever force you or your family member that shares those values to have an abortion. But many people do not agree with that. Many people believe that there are various circumstances under which abortion is reasonable medical care and should be an option available. In the case of rape and incest, for example, or in a situation where there's a fatal fetal anomaly and a healthy child will never be viable. Amendment G has to do with who makes those decisions. The proponents of Amendment G believe that those are personal decisions the government ought not make, that we believe individuals, women, girls, their families, couples should make their own decisions. Just as no one would force someone to have an abortion, we believe no one should be forced to give birth.
You may respond.
Yes, so Amendment G is a radical, inhumane amendment here that, first of all, strips parental rights. Second of all, allows abortion up till birth for nearly any reason. And number three, it rids all health and safety protections for women. This takes us back to the dark ages, you guys, and this is a dangerous amendment for women and children all across our state. I am so proud to be a mother here in South Dakota who stands for women, who wants to protect women, and this amendment actually rids all of those health and safety protections we already have in the books. This includes things like having a clean and safe environment to have any kind of medical procedure. It also entails having informed consent laws. It protects women by notifying their parents if a rapist or a sex trafficker is coming in and forcing or coercing a daughter to have an abortion. I am here to say that this is an inhumane, radical abortion amendment allowing abortion up till birth for nearly any reason. And let me just tell you this, the U.S. Supreme Court defined health to include all factors. This includes things like, it says physical, emotional, psychological, familial, and a woman's age. This means for nearly any reason an abortion doctor can justify an abortion. As a mother who had a high-risk pregnancy, I could have justified abortion for any reason under Amendment G, and that's really unacceptable here.
That's absolutely not true. Nothing that has been said is true. Parental rights are not changed by this. There will still be a need for parental consent for an abortion if the patient is a minor. Abortion up to birth is a slogan. It's not a reality. It doesn't exist. If a woman is approaching term and for some reason her health or safety requires that the pregnancy end, a doctor doesn't abort a fetus. They deliver the baby. And it's absolutely false to say that this amendment would eliminate all safety regulations. That's absolutely not true. South Dakota has blanket regulations that
10
apply
seconds.
to physicians and clinics. Those would still be in place.
The next question goes to you, Carolyn. The law as it stands now in South Dakota, and which would be the law of the land if Amendment G does not pass, says that an abortion is only allowed when necessary to preserve the life of the pregnant female. What guidance do doctors have to ensure that they don't violate this? How can they know what this language means in the real medical world?
Yeah, thank you for the question. So for someone who actually had a miscarriage more recently, and for someone who has had a sister who almost died of an ectopic pregnancy, I'm here to tell you that the abortion lobby is lying to all of you guys. A doctor should use their sound medical judgment to make decisions based off of law. And every single state who has pro-life laws like ours has an exception for the life of the mother, and it's very clear that you save the life of the mother. There are stories being touted all across the nation saying, oh, these, pro-life measures are, destroying women and hurting them. No, that is not the case. Any doctor with any kind of sound medical judgment will not ever harm a woman. They will attend to her needs immediately, just like my sister got care, just like I have gotten care. This is something from the abortion lobby that they have continued to tout and lie to the American people, especially here in South Dakota. And in this Amendment G, it's actually going to rid all health and safety protections. And I'm holding up the language verbatim. As my opponent had mentioned, it does not rid any health and safety protections. Well, that's in fact not true. It says, before the end of the first trimester, the state may not regulate a pregnant woman's abortion decision and its effectuation, which basically means to bring about an abortion. There is zero protections for women. Parental right notifications, out the window. Informed consent, out the window. Your daughter comes in as a minor who has been raped and now has a sex trafficker
10 seconds.
telling her that she has to get an abortion, out the window. You as a parent don't get to know. We have laws in the books that protect women, and this does the opposite.
None of that is true. Doctors in South Dakota today face a felony if they act too quickly to try to treat a woman who is in need of an abortion. They are confused about what care can legally be given to women who are having problems, whether it's a miscarriage or some other less common difficulty with pregnancy. And doctors deserve to be able to practice their profession without the threat of a felony conviction hanging over their heads. There are all sorts of regulations that apply generally to all health care. You must be a physician, for example, to practice medicine. You must get parental consent if you're going to treat a minor. Those regulations are not gone. Those are just boogeymen that the opponents have cooked up to try to scare vulnerable voters. This amendment is taken from a framework that was established by 7 old wise men on the Supreme Court in 1973, most of them appointed by Eisenhower or Nixon. To claim that it's extreme or radical is totally disingenuous.
This next question is for Nancy. How will Amendment G coexist with South Dakota's current abortion ban? Would South Dakota's abortion ban be completely repealed?
Yes. South Dakota has one of the most extreme abortion bans in the nation. There is no exception for rape and incest, even though we have one of the worst rates of rape in the country. It's estimated that there are about 800 rape-related pregnancies in South Dakota every year. But there's no exception under our current ban. There's no exception for the health of the mother under South Dakota's current law. There's no exception for anything unless the doctor feels confident that the woman is so close to death that an abortion is necessary to save her life. That ban will be completely repealed by the amendment. And I'll tell you why it's in the constitutional amendment form. Because South Dakota voters twice before have told the legislature with the statewide election that they don't want this ban. They voted it out in 2006 and again in 2008, but the legislature won't listen. It keeps ignoring the will of the people and adopting a radical position that reflects the view of some very extremist politicians. So this will put it into the Constitution so the legislature can't ignore it the way they have in the past.
Can I respond? Yes. So under Amendment G, you actually don't have to be a doctor to perform an abortion. It would actually allow black market abortions to be happening. And the language right here, any lawyer should know that this allows abortion up to through all 9 months. And during the first trimester, there is no regulations, 0, which means you don't have to be a doctor. You don't have to have any kind of experience to give an abortion. And this puts women in great danger. It opens the black market for abortions. There's zero ways, as Nancy actually just pointed out, 0 way for the legislature to even go and help these women. And mind you, Planned Parenthood doesn't help with miscarriage. They don't help with ectopic pregnancies. They don't help with any of those things, and as they claim to be helping women. This doesn't help women. This hurts women. And I have my friend Dr. Patty Giebink, who is a former abortion doctor, and she can tell you that Planned Parenthood and the abortion lobby is not here to help women. They're here to hurt women. They're here to pad their wallets because they want abortion up to birth. This means a 6-week-old child in the womb who has a heartbeat and we can detect it will be aborted. This means a 12-week-old who can feel pain will be aborted. This means
10 seconds.
A child that's about to be born can also be aborted for almost nearly any reason. That is something that's inhumane, and it's atrocious to be something in the Constitution here in South Dakota.
Nancy, I know you want to respond, but we want to get to other questions.
Okay.
Yep, this has to be our last question before closing statements.
We have one more question. Time prevents us from really going further, unfortunately. This goes to you, Caroline. How does the state enforce the abortion law currently in place in South Dakota? Will and does it access medical records of women in order to ensure that medical professionals are complying with the law?
Yeah, so right now, actually, our Secretary of Health did a fantastic video clarifying our current laws. I know Nancy had just mentioned that doctors are very confused. Well, I'm here to tell you that if they're confused about saving the life of a mother and attending to her, then they should have their medical license revoked. That's absolutely atrocious for any doctor to not know what to do to save the life of a mother. So I think that's one for very clear. 2, here in South Dakota, we are here protecting women. We are here to examine what their needs are. And I'll just tell you right now, Amendment G does not attend to any health care needs. It hurts women dearly. As far as anything medically related, they won't get the help that they need. The black market will come here. There will not be doctors, mind you, that will have to give an abortion, given the fact that most abortions happen the first trimester, and that's why we have here the Wild West, where no medical intervention, and we'll be leaving women here to die, to have infections, to have no care, as Nancy and the group have pointed out. They want to save people. Well, they're not. This is actually doing the opposite of that.
We need to move into closing statements. You'll have. Oh, I'm sorry.
I can't respond to this?
I apologize.
Please?
Yep.
All right. It's amazing to me that the opponents want to criticize doctors and insult them so badly and suggest that all they have to do is watch the video. South Dakota's law is so ambiguous as to the care doctors can safely and legally give women that at the end of the video that the Department of Health put out, they ended it with a disclaimer and told doctors don't rely on this. Moreover, none of the statements in here are legally binding. The state itself can't explain and is not confident with its explanation of South Dakota's abortion law. We do know that you have to be a doctor. It's nonsense to suggest otherwise. All medical care in South Dakota is requires that you have a medical license. It's a crime to practice medicine without a license. And this nonsense about all 9 months is just that. For 52 years, it has been legal in South Dakota to perform an abortion throughout the entire pregnancy to save the life of a woman. For 50 of those years, it was legal to perform an abortion throughout pregnancy to save her health or her life. There has never, in 52 years, been an abortion at or near birth. That's just a slogan that a gruesome nonsense that these folks have cooked up to try to scare voters.
We'll now move to that 1-minute closing statement. Nancy Turbach, you go first. 1 minute.
Thank you. South Dakota's current abortion ban is extreme. It denies relief to victims of rape and incest. Last night in Sioux Falls, I talked to an OBGYN that told me her youngest rape patient that she treated for pregnancy was 9 years old, a third grader with a teddy bear. In South Dakota, such a victim has to carry her child to term. Doctors fear of felony prosecution if they step over the line and take care of people too soon if they're having a miscarriage or some other pregnancy complication. Women, couples, and families should make the decision, not the government. And that's why we have a big coalition. We have Doctors for Freedom, Lawyers for Freedom, and earlier this week, 35 clergy leaders joined us and said, Clergy Leaders for Freedom. The constitutional amendment is needed to get rid of our extreme abortion ban. It's time the people take the power. The legislature won't respect, they never have, and so we need to adopt a constitutional protection to take us back to the days we had for 50 years under Roe versus Wade. That's all this amendment does. And I urge you to get us back to at least that same territory that for 50 years we had until 2022. Vote for Amendment G.
Caroline Woods, 1 minute, closing.
Yes, I know a lot of different people have different opinions on when abortion should be legal, but I'm here to tell you Amendment G goes too far, it's too inhumane, and it's too radical. Under Roe v. Wade, as my opponent has been touting, the fact of the matter is it was only legal up to 22 weeks, and most of them didn't happen until, I think, even before 15 weeks. And this is not the case with this amendment. This amendment goes terribly too far. This is the amendment right here. You can go to lifedefensefund.com and view it yourself. This is what the laws would say, and it's very vaguely written. It's poorly written. Talk about confusing doctors. This is not a good amendment. This is vague. This will open the black market up for people to have abortions. It will be unsafe. It will be unclean. It doesn't have to be inspected. That's a dangerous place to put mothers like me in those kinds of positions. And I'd be ashamed if our state condoned that kind of behavior. I'm here to tell you that babies should have a chance. At 6 weeks, they have a heartbeat. At 12 weeks, they can feel pain. I don't know about you guys, but I don't want any baby feeling pain. That's inhumane. And at 21 weeks, they can survive outside the mother's womb. So I'm here to tell you this is too radical, this is too far, it's on par with North Korea and China's policies on abortion, and it also gives us, our unborn babies, less rights than animals have right now. Thank you.
That's our time for Amendment G. Thank you to our participants, to our journalist and student for the questions. During the 2024 legislative session, lawmakers passed Senate Bill 201, and Governor Noem signed it into law. Enough valid signatures were collected to place Referred Law 21 on the ballot. The act passed by lawmakers authorizes counties to impose a $1 per foot surcharge on carbon dioxide pipelines for any tax year in which the pipeline operator receives a tax credit. Revenue from the surcharge must be distributed as tax relief to each property owner in the county where the pipeline is installed. Any remaining revenue can be allocated at each county's discretion. No other fee may be imposed except property taxes or fees associated with road agreements. A yes vote on Referred Law 21 allows the act of the legislature to become law. A no vote rejects the act of the legislature. Advocating for a yes vote is Walt Bones. The NewGen ethanol plant in Marion and the main line will cross his property. He's a member of the board of directors for Protect South Dakota's Ag Future. Jim Eschenbaum is the chairman of the South Dakota Property Rights and Local Control Alliances. He is speaking in opposition of the act of the legislature. J.P. Skelly with KORN Radio and DWU student Alex Zachmeyer will ask the questions. You may begin.
If there are those who are opposed to having the pipeline run through their territory and land, what rights would the landowners retain under the amendment?
I'm sorry, I couldn't hear that question.
Sorry. If there are those who are opposed to having the pipeline run through their territory and land, what rights would the landowners retain under the amendment?
Go ahead. Who do you want?
Is that directed to anyone in particular?
No.
All right. Mr. Bones, why don't you start?
Oh, I'm sorry. Okay. Well, thank you. Thank you, Alex, and thanks to DW for hosting this. There are, the Senate Bill 201, as Jackie just said, is called the Landowner Bill of Rights. That's kind of what it's been dubbed. And there's a lot of things in there that talk about the rights of landowners. And so as we go through, this discussion today, there are things that I could probably put those rights in probably 3 buckets, okay? The first bucket is protection. So there's a lot of liability, indemnity. There's, if they go through, the land needs to be returned back to the same way that it was. Any damage from any potential leaks, there's total liability protection against that. The easements is a big thing as a family farmer. Decisions that I make shouldn't have to go into perpetuity so that, my grandkids don't have to worry about decisions that I make. So it limits it to 99 years. It says if the pipeline doesn't run for 5 years, the easements are void. If the project doesn't get off the ground for 5 years, the project is void. And so, again, there's a whole bunch of that's one bucket. The second bucket is a financial compensation for counties and for the landowners. $1 a foot gets charged per lineal foot, and so that's $3.6 million that gets done. And then there's a safety bucket. So the
10 seconds.
I'm sorry?
You can wrap up.
Oh, I'm sorry. Okay. So then the third bucket would be the safety bucket. So the pipeline needs to be put in deeper than the federal regulations. And also the research, there's been a lot of research done on what if happens, if a pipeline would happen to rupture, if something would happen. All those research studies have to be publicized.
A response?
So I am not only chairman of the South Dakota Property Rights and Local Control Alliance in this referral effort, I also serve as a commissioner in Han County, county commissioner. Senate Bill 201, which is now referred Law 21, takes away the voice of those local governments. The legislature said because these counties passed ordinances that put setbacks in place for safety reasons, because this is a hazardous materials pipeline, they said, well, you can't do that. You can't change the rules in the middle of the game. The legislature most indeed changed the rules in the middle of the game by passing this law. I don't know, when your question about how this affects property rights, whether a landowner wants it or not, that is in regards to eminent domain. There is not wording in this law in regards to eminent domain. My concerns about it is if you understand how eminent domain works, and eminent domain condemnation was filed against 162 landowners in South Dakota in this first round of application for this pipeline. Eminent domain, a judge grants. Eminent domain, a jury decides just compensation. I'm afraid with the wording of this law that it will affect eminent domain. When this goes to court,
10 seconds.
The courts are going to say, it looks to me like all of the parameters have already been put in place, the deal's been made, and I'm afraid it will affect that decision.
A 30-second rebuttal.
Yeah. Jim was right. There is nothing about eminent domain in this bill. In fact, eminent domain is out of my hands, it's out of Jim's hands. In fact, it was in the state Supreme Court, and it just most recently got deferred back into the circuit courts for some more research, more input. So that is there. As far as this point, there is no wording in Senate Bill 201, now referred to Law 21, that diminishes the county's rights in any way. Initially, frankly, there was, but to get through the legislature, that was all stricken out. So there's nothing in there right now that restricts the counties any more than what they did.
Next question.
May I rebut and read from the law?
We need to move to the next question to keep the format, please.
If referred Law 21 is defeated, what protections are currently available to property owners opposed to the project? Jim?
Everything that's in there that's supposed property owner protections, Summit has said in our commissioner chambers in Han County that they will bury the pipeline 4 feet deep. They said they will repair your drain tile if they cut it. There's already laws in place to protect people and landowners if somebody damages your property. You take them to court and you receive compensation if you win in court. Nothing in here guarantees that that's going to solve the problem for anybody. It will be a civil matter. You're still going to have to take them to court to get your just compensation. So some of the legislators said, well, now that we have it in law, you won't have to sue them to get compensation. You will still have to sue them. It's a civil matter. So it does not solve any problem with damaging your property or whatever else. And all of these protections that are supposedly in this rosy titled Landowner Bill of Rights, this is a pipeline Bill of Rights. This is not a landowner Bill of Rights. Someone already has said they would do all of that. Nothing has changed there.
Thank you. Again, this referred law 21 is not a referendum on a pipeline, first and foremost. Has nothing to do with it. If it passes or if the voters decide to reject it, the pipeline can still be built. So as a landowner, and the fact that the legislature proactively took these things and put it in statute, potentially, if this passes, I feel a whole lot better about that. One of the testimony at the PUC hearing when the Navigator pipeline was being discussed said that, yeah, this stuff is all in contracts, but again, this is a state legislator who said this. I would feel a whole lot better if we put this in state law. So they did it. And so, I would feel a whole lot better with this stuff being in the state statute than just in a contract.
Mr. Eschenbaum, you'd have a 30-second rebuttal if you like.
The fact that this is put in statute is, I've said so many times, the legislature has no business negotiating terms on people's private property. Be it this $1 a foot or whatever, every landowner can negotiate this in their contract, in their easement contract with the pipeline company. They have a right. As a matter of fact, I know of a landowner in Han County that did sign an easement, and they said, I want that pipe 6 feet deep. They said, okay. They put it in their easement. So why do we need to put this in statute when it is up to each individual landowner to negotiate the terms on their property?
We have time for one more question before closing statements, please.
What steps are being taken to implement Referred Law 21 if passed, and how will its success or effectiveness be measured over time?
What step? I'm sorry, I'm having a hard time.
It is hard to hear the question.
Yeah, it really is. I'm sorry, Alex.
What steps are being taken to implement Referred Law 21 if passed, and how will its success or effectiveness be measured over time?
What steps would be taken if it wouldn't have gotten referred, if Jim and the group wouldn't have gotten the signatures, it'd be state law right now. It would have went into effect July 1st. So as soon as the will of the voters is said here, if it's passed, if a yes vote guarantees me as landowners and my family all of these covenants that are in there, I'm assuming it'd go into state law at some point in time. I'm not sure exactly the date, but soon after.
A response.
So, being this was referred, the title Senate Bill 201 doesn't apply anymore. It is now Referred Law 21. If this is voted down, we ask people to vote no. If this is voted down and this law is killed, then we're back to where we were in the beginning. If a yes vote wins on this, it's my understanding that the law does go into effect on July 1st of 2025, that it would be delayed to that point.
Mr. Bones, you'd have 30 seconds to rebut if you like.
Yeah, I guess I don't know the date, when it goes into effect, other than, it will at some point in time.
We'll move on now to our 1-minute closing statements. Mr. Eschenbaum, you may go first.
Okay, this law was a sellout to Summit Carbon Solutions, outright sellout of the South Dakota citizens to Summit Carbon Solutions. The only thing they preach is look at all the money this is going to bring in. Let's go to their revenue part of their business model. They produce nothing of value. They produce no public service. They are going to they're going to collect their money totally on the taxpayers' backs with federal tax credits. So if they're going to give $1 a foot to the landowners, that comes from you. If the tax revenue, the property tax revenue that they generate comes from you, they produce nothing of value. Every bit of the expense of this pipeline is on your back.
Mr. Bones, 1 minute closing statement.
Well, first, thank you very much for this opportunity. At the last legislative session, multiple stakeholders worked tirelessly with our legislator to proactively create a set of landowner protections and another source of funds for our counties. A majority of the South Dakota House, a majority of the South Dakota Senate was passed, and the efforts of the governor were signed. Bottom line, nothing more, nothing less, protections for landowners and funding for counties. As a landowner and as a taxpayer, I appreciate these proactive efforts. So don't be misled, folks. Go to the Secretary of State's website, go to our Protect South Dakota Ag's website, read the Attorney General's opinion or summary that Jackie did before. This is all about landowner rights and getting another funding source back to counties. That's all this is. It's not a referendum on the pipeline. It's nothing more than this list of landowner rights and protections and a funding source. So please, before one shovelful of dirt, again, this is a proactive effort by our legislature to protect landowners.
10 seconds.
I ask you to please vote yes and help out family farmers and landowners like myself. I appreciate that. Thank you.
That's our time for Referred Law 21. Thank you to our participants, to our journalist and student for the questions. Initiated Measure 28 prohibits taxes on anything sold for human consumption. Currently, the state collects tax on the sale or use of certain goods, including foods and drinks. Many municipalities also collect these taxes. Initiated Measure 28 prohibits the state from collecting sales or use tax on anything sold for human consumption. The measure eliminates these sources of revenue for the state. Human consumption is not defined by state law. However, its common definition includes more than foods and drinks. The measure does not prohibit the collection of sales or use tax on alcoholic beverages or prepared food. Prepared food is defined by law to include food that is sold heated or with utensils. A yes vote adopts the initiated measure. A no vote leaves South Dakota law as is. Rick Weiland is the co-founder of Dakotans for Health and is an advocate of Initiated Measure 28. Nathan Sanderson is the executive director of the South Dakota Retailers Association and speaks in opposition of IM 28. Questions are being asked by Seth Tupper with South Dakota Searchlight and DWU student Garrett Mertens. You may begin.
We'll give the first question to the sponsor, Mr. Weiland. Backers of the measure say that this would only remove the state sales tax on groceries. Opponents say that because of the wording of the measure, it could inadvertently remove taxes on lots of other goods and services. I was wondering if you could both give us your argument on that point.
Yeah, I mean, I'll just start with the Attorney General's statement, which was read. It says this initiated measure prohibits the state from collecting sales or use tax on anything sold for human consumption. In the second sentence is this measure eliminates these sources of revenue for the state. That's what the Attorney General said. The actual measure itself was 2 sentences. It was on the petition that 25,000 people signed, and it says, notwithstanding any other provision in the law, the state may not tax the sale of anything sold for human consumption. The state, right? Except alcoholic beverages and prepared food. And it also says in the last sentence that municipalities can continue to collect the tax. But it doesn't stop there. When you look at the fiscal note that was put together by the LRC, when you go and you submit a measure for consideration, you go through the LRC. The LRC did their fiscal analysis based on taxing food at the state level and removing it. And that was $123.9 million. And in that fiscal note, it also says municipalities can continue to collect the tax. So I think it's extremely clear that what the voters' intention is consistent with the language and with what the Attorney General and the LRC have said. So this whole idea of this harming municipalities is simply, I would argue, a scare tactic.
Mr. Sanderson.
I think your question was related to the language in the measure, whether or not this is groceries or anything sold for human consumption. The measure says that the state may not tax the sale of anything sold for human consumption. Let me read you the definition of tobacco product in South Dakota law. It's any item made of tobacco intended for human consumption, including cigarettes, cigars, pipe tobacco, and smokeless tobacco and vapor products. Let me read you quickly the definition of electronic smoking device, which is any e-cigarette, e-cigar, e-pipe, e-hookah, or vape pen containing or delivering nicotine or any other substance intended for human consumption may be used by a person in any manner for the purpose of inhaling vapor or aerosol from the product. It's very, very clear from both the Attorney General's statement and from the definitions that I read you in South Dakota law, this isn't restricted just to food. The Legislative Research Council's updated fiscal analysis of up to $646 million includes a whole variety of things other than food and food ingredients, and it's very clear that this isn't just limited to food.
Well, it is. That's what the fiscal note that the voters saw and what is on the petition that they signed said, and that would become the law of the state when this passes. And this whole idea of $646 million, Nathan's talking about $335 million for services. There was nothing in the petition or in the fiscal note or in the Attorney General's explanation that said we were going to take the sales tax at the state level off of services at $335, at energy at $91, at tobacco at $42, at personal health care at $17, paper and stationery at $15, and other consumables. We are up against a campaign of fear, which a lot of the local jurisdictions now are thinking they're going to lose that right to tax. We're up against a campaign that has expanded the definition of what the LRC, what we intended, would be taxed.
10 seconds.
10 seconds?
Mm-hmm.
So, I mean, you have to look at it in that context. It's not an attack on municipal governments and their ability to tax, and it certainly isn't $646 million. It's just, you say something like that, and it's like, oh my God, that's a budget crisis waiting to happen. That's just not the truth.
Next question.
Where will the replacement fundings come from if we eliminate the food tax?
You want me to answer that?
Nathan, yep.
Well, I think you've accurately identified one of the key reasons that the South Dakota Retailers Association and a coalition of 50 different organizations around the state are opposed to IM 28. It's because there is no plan for replacing the revenue. And whether it's $123.9 million, which is the low end of the estimate that the Legislative Research Council gave a year ago, or whether it's $646 million, which is the high end of the Legislative Research Council estimate, either way, we're still talking about more than $100 million of lost revenue to the state of South Dakota with no plan for making it up. Our organizations believe that this is going to lead to significant tax cuts to things like education, health care, that make up 80% of our budget, or it's going to lead to higher tax increases for things like your local property taxes, which pays for education, or even potentially a state income tax. The reason that there's no potential replacement in the funds here is absolutely one of the key reasons why we think that IM 28 isn't the right fit for South Dakota.
Well, it's a campaign of fear, and it's a campaign of hypotheticals. Let me just read to you something that was said during the time that this was being debated in Pierre, when the governor of the state of South Dakota was advocating removing this tax. And this language comes from two very conservative state representatives. Let me read this. Eliminating this tax will make it easier for South Dakota families to make ends meet, including my own kids and grandkids, said Representative Mary Fitzgerald. As a former appropriator, I'm confident our state budget can afford this while still still planning conservatively and responsibly for the future. Here's what Senator John Wick, who's the chairman of the Republican Party, said at the time. We hear a lot from the special interest groups in the Capitol every year, but it's time that we lobby on behalf of the taxpayers, said Wick. As we continue to shatter our state's revenue records, legislators must ask ourselves how much is enough before we finally give it back to the people. Even with conservative projections for future revenue growth, we can afford this tax cut. 10 seconds, said Jim Twilliger, Commissioner of the Bureau of Finance and Management. The governor has consistently provided large funding increases to schools, medical providers, state employees, and other groups. This proposal adds a group that's too often ignored, the South Dakota taxpayers. That's when the governor wanted to pass this.
Very briefly.
Right?
That was in January of 2023, before the legislature reduced the overall sales tax rate from 4.5 down to 4.2, cutting more than $100 million in the budget. Initiative Measure 28 would add an additional up to $646 million out of our state budget. That's not in lieu of, that's in addition to the earlier cut, and clearly is above and beyond anything that South Dakota can do without cutting things significantly or finding a new revenue source.
And I get 30 seconds on that, right?
No, we started with Wyland.
I think
Next
I
question.
get 30
Yeah.
seconds on that.
Well, I think the next question, on the topic of the governor, the governor's bill to remove the sales tax on food would have reduced the percentage of the tax to 0%. And that's been a topic of debate among you two. This measure would apparently just remove the tax rather than reduce the percentage to 0. For Mr. Wyland, why didn't you just adopt the governor's bill language? And for Mr. Sanderson, why do you think that the difference in the two drafting approaches is significant?
Because our amendment had already been, we were really hoping that the governor was going to be successful, so we didn't have to be. And she wasn't successful, and we'd already developed the language, and we were ready to circulate, number one. But the other thing to keep in mind, and this is another false argument coming from the other side, is that consider this initiative process as the voters are the legislature, right? They pass a law. It's the law, and it supersedes the existing laws. So whether it's 0% or 20% or whatever, it just doesn't matter. This law supersedes, when it passes, what's on the books. So this idea of 0, I've said this to Nathan, several of these things. Well, it's an initiated law, so you know what? I guess if the legislature is going to feel more comfortable about making it 0, that's a technical thing. They could clarify that. Just don't mess with the rate, because 106,000 South Dakotans are food insecure, according to Feeding South Dakota. That means they don't know where their next meal is coming from. And of those, 1 out of 6 are kids. And we could have done this with the governor, and she said, make that tax cut temporary, and it is. So if we're worried about not being able to pay for it, they just don't have to renew that 0.3%, and they can give that $100 million to the families that need it most, that are spending over 30% of their household income just to put food on the table.
The governor's bill was fundamentally different than Initiative Measure 28 in 2 key ways. The first is that it used the terms food and food ingredients, which are defined in state law, unlike the term anything sold for human consumption, which is not, as the Attorney General noted. The second key difference between the governor's bill, House Bill 1075, in this measure is that the governor didn't eliminate the state's ability to tax. It set the state rate at 0. There were 2 main reasons for that. One is, as the Attorney General's statement notes, Initiative Measure 28 interferes with South Dakota's involvement in the Streamlined Sales Tax Initiative. Setting the rate at 0 would not. The other key reason that the governor's bill set the rate at 0 was because of South Dakota Law 1052-2, which says that municipalities can only collect taxes if such tax conforms in all respect to the state tax on such items, with the exception of the rate. But another way, if the state can't tax it, a municipality can't tax it. That's why there's 75 communities around South Dakota that have passed resolutions in opposition. But if the governor's bill, House Bill 1075, set the rate at 0, municipalities would continue to be able to impose that tax. That's a key difference between the 2.
Can I respond to that?
30 seconds, yes.
Okay. Well, not according to the Legislative Research Council, Nathan. And they just weighed in 2 weeks ago. And here's what they said. In speaking with the Legislative Research Council, this was Dakota News Now, municipalities may have the chance to tax anything sold for human consumption. If IM 28 passes because it's a later law, would take precedence over an earlier law. That's the way this works. We become the legislature, your legislators, you vote for this, it's the new law. And it supersedes what Nathan's talking about. That has no impact. And when you look at what the Attorney General said, this is affecting the states.
10 seconds.
Tax on groceries, not the municipalities. So, I mean, we have honestly, a difference of opinion here, but we're dealing in facts. You're going to go into the voting booth, you're going to see the Attorney General's explanation, you're going to see our language, and you're going to see the fiscal note that says that municipalities can collect tax, and it's $123 million because it's being taken off of food, not toilet paper.
We have time for one more question before closing statements.
With the food stamp program in order, why would we need to remove the sales tax on groceries?
With a food stamp program, because there's a whole group of people that don't qualify for food stamps, okay? They're making $30,000 a year, $40,000 a year. They've got a family, 3, 4, 5 kids. Those are the folks that are spending upwards of 30% of their household income just to feed their families. That's why. Every state, with the exception of 2 in the country, have done this. They've either reduced the tax to 1% or no percent, or they have provided tax credits. They've gotten rid of it completely. South Dakota is one of 2 states. The other state's Mississippi. And they're talking about doing it in the next legislative session. And their legislature is made up like ours. It's about 95% Republican, about 5% Democrats. We'll be the last to do this if this doesn't happen, because I'm confident Mississippi's going to get it done. Their governor is a Republican, their attorney general is a Republican, their secretary of health, who is a Republican, all want to do this because they see this as being unfair and morally wrong.
There's no question that it makes sense to help those in South Dakota who are of fewer means than some of the rest of us. That's why the SNAP program, WIC, other programs don't charge sales tax on the food that people buy. Individuals in the SNAP program and the WIC program don't pay sales tax on those items. I would submit to you that South Dakota's budget can't afford a $646 million hit. Municipalities can't afford a $51.5 million hit. That's why so many municipalities have passed resolutions in opposition to this, why so many organizations are opposed. On the state level, I'd submit to you that passage of IM 28 is going to hurt those people who depend the most on public services. Education and healthcare are 80% of our state budget. There is no way we can absorb a hit of even $133 million at the low end of the legislative estimate, much less $646. And the people who depend on those services most, like public education, like healthcare, like Medicaid, are going to be the most impacted by the cuts that are going to be needed by the legislature in order to balance the budget. IM 28 is just too irresponsible, and it impacts the lowest income South Dakotans the most. Despite whatever good intentions may be behind the measure, it's just poorly drafted.
30 seconds.
There have been a lot of good intentions over the last 20 years to do something about this. They never seem to get done in Pierre, okay? And for lots of reasons. WIC points out, the chairman of the Republican Party, we hear a lot from special interest groups in the Capitol every year, but it's time that we lobby on behalf of the taxpayer. I have a list here of $1.4 billion in sales tax exemptions in the 2025 budget, representing agriculture, representing healthcare, representing tourism. You can just go down the list. There's even pipeline sales tax exemptions in here. There's sales tax exemptions for bull seamen and rodeo clowns.
10
We're
seconds.
talking about families in South Dakota that are struggling. You know, I don't agree with Governor Nome on much, okay? That should be not a surprise. But I certainly agreed with her on this. She was out and about campaigning, decided after a career of opposing it that she was going to support it. And she warned the legislature that if they make that tax cut permanent, they're going to have a huge budget crisis. They didn't. So they can start there, Nathan, by not re-upping that tax cut of 0.3%. And take a look at this, and take a look at the Wayfair tax, which is also some additional revenue.
That's time. We are moving now into the 1-minute closing statement we drew before the program. Mr. Weiland, you go first. 1-minute closing statement.
We've been talking a lot, and I know that what I think now the core argument is from the opposition is the $646 million, the consumption tax, not the food tax. I can only restate to all of you that when the LRC put this together, they took the tax off of food at the state level, and it was $123.9 million. And that's what you're going to see when you go in the voting booth, because that's the official position of the state of South Dakota, not Nathan's organization of $646 million. And let me just share something else that I really wanted to get in the mix here. The South Dakota Secretary of State basically said the vote on the measure would mean that human consumption cannot have any further elaboration at the polls. Right? It's based on what the LRC says it's based on with their fiscal note of $123.9 million. So you just can't all of a sudden come up and scare people and say, you're going to lose your ability to tax at the municipal level, and by the way, it's going to create a $646 million hole in the budget. It's not true. It's simply not true. And let me just, I don't know which time.
10 seconds.
10 seconds. Well, there are a number of things in here that I'd love to share with you about fiscal projections that came out of the governor's debate on this in Pierre in 2023, that we're strong. We can do this, whether it's not expanding or continuing the state tax of 0.310%, rolling that back, the Wayfair tax, which is the internet sales
Wrap up, please.
tax, and then the fact that there's $1.4 billion in tax exemptions that we should look at.
Mr. Sanderson, 1-minute closing statement.
Thank you for the opportunity. Initiated Measure 28 would eliminate the state's ability to tax anything sold for human consumption, except alcoholic beverages and prepared food. Earlier, I read you a definition of tobacco product, an electronic smoking device, that both include the term intended for human consumption. There is just no way that this is only limited to groceries. The Attorney General agrees with that. If you read in the Attorney General's opinion, which you'll all see on the ballot, it says human consumption is not defined in state law, but its common definition includes much more than food and drinks. The Legislative Research Council also recently said that the estimated impact is between 133 million and 646. We can have a conversation about what that number actually is, but cutting $100 million out of South Dakota's budget at minimum is going to lead to one of two things. It's going to lead to programmatic cuts to big things like education and healthcare, or it's going to lead to other tax increases, whether that's a sales tax increase to more than 5 because you're eliminating food, or local property tax increases to balance your school budgets, or the potential for a state income tax. We don't think that that's the right fit for South Dakota. We'd urge you to join the coalition of more than 50 organizations, more than 75 cities and towns in this state that have passed resolutions in opposition. Don't take the bait and vote no on IM 28.
That is our time for IM 28. Thank you to our participants, to our journalist and student for your questions. There is one additional constitutional amendment on the ballot, Amendment E. This updates gender references for certain office holders and persons. The South Dakota Constitution became effective upon the state joining the United States in 1889. The generic male pronouns he, his, and him are used in the text of the state constitution to reference certain office holders or individuals. This amendment changes the text of the state constitution to remove the use of generic male pronouns. For example, when referencing the governor, instead of saying he shall be the commander-in-chief of the armed forces of the state, the text will read the governor shall be commander-in-chief of the armed forces of the state. The amendment makes similar changes to other references to the governor, as well as references to other office holders, including lieutenant governor, Supreme Court justices, and circuit court justices. A yes vote adopts the amendment to the state constitution. A no vote leaves the constitution as is. That is all the time we have tonight. I would like to thank the McGovern Center at DWU, Dakota Wesleyan University, Carson Walker with South Dakota News Watch, and all of our media partners, KMIT, KORN, KOTA TV, South Dakota Searchlight, Forum Communications, and Sioux Falls Live, and South Dakota News Watch. You can find more information about the election at votesouthdakota.com. For all of us with SDPB, I'm Jackie Hendry. Thank you for watching.